Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello everybody. So I guess you can pretty much guess why we're here today. We're here to talk about Miss Nirider and her response to Brad Schimey and them asking for their on-bank review. So here we're going to see her go through her list of arguments, basically saying why the on-bank review is not warranted. Basically, that Brad Schimey's biggest claim here is that new ground was broken in the terms of coerced confessions. The fact of the matter is, she very eloquently states that there is no new law here. This is just application of established Supreme Court law. And anyway, it's quite interesting. So, how much do we love Miss Nirider? This much. But of course, Weegs, has no love for Miss Nirider. So, alright, so let's get on with it. We'll move into the documents now. Almost none of these unique and unmistakably problematic facts were addressed by the state court, which unreasonably failed to apply the totality of circumstances test, or to do so in light of the particular characteristics of the defendant, as mandated by the Supreme Court law. After painstakingly analyzing these facts and appropriately applying long-established Supreme Court law, both appellate majority and district court granted habeas relief. In so doing, the Dassey decision followed a long line of similar cases and created no circuit splits or questions of exceptional importance. The appellant's petition for rehearing and rehearing en banc should be denied. And that's really the important thing here, because Brad Schimey is claiming that this court has made a decision that just completely goes, doesn't follow any previous Supreme Court law or whatever. It does follow it. Brad Schimey knows what the totality of circumstances is. He just doesn't want to. He doesn't want to have to acknowledge it. He knows that special care is required. He just doesn't want to acknowledge it. He realizes that he should realize that Brennan had special issues that needed to be addressed, and they weren't. The appellant claims that the Dassey court created a new rule in applying special care to analyze the voluntariness of Dassey's confession under the totality of circumstances. Now there is apparently a different test. That's quoting Brad Schimey. Like the state court's decision, this position is unreasonable. Many courts for many years have held that while the totality of circumstances test applies to both adults and children, the voluntariness of juvenile confessions must be evaluated with special care. Gilbert v. Merchant, Hardaway v. Young. Special caution is required for juvenile confessions. U.S. v. Sublotny. Special care requirement is a long-standing principle. In R.E. Galt, confessions by juveniles require special caution and the greatest care to assure that the admission was obtained voluntarily. This juvenile standard is more sensitive than that applied to adults. Woods v. Cluson. Because it means a lesser quantum of coercion would render a juvenile's confession involuntary. It takes less to interfere with the deliberative processes of one whose capacity for rational choice is limited. In a decision from 1962, no matter how sophisticated, a juvenile subject to police interrogation cannot be compared to an adult. So, you notice a lot of those decisions she was referencing were from the Seventh Circuit Court itself. Just thought I'd point that out. Finally, the appellant argues that Dassey differs from the circuit's voluntariness rulings in Etherly v. Davis, Carter v. Thompson, and Hardaway v. Young. But both district court and appellate panel easily distinguished those cases. Hardaway sought a per se rule that parental absence renders a juvenile confession involuntary, even in the absence of coercive tactics. Carter involved a juvenile who, while detained at the station house for 55 hours because she had nowhere else to go, similarly confessed impromptu in the apparent absence of police pressure. and Etherly involved a defendant who was truthfully told only once that if he confessed, it would go better for him in court. A lone error. This solitary moment of pressure is a far cry from the dozens of false promises and assurances that if Dassey confessed, he would be set free, and that everything would be all right. Tactics that combined with relentless pattern of steering, coaxing, fact-feeding, and cueing, followed by rewarding the correct answer to produce a parroted back confession that raises significant doubts as to its reliability. None of these cases split with Dassey. None warrant rehearing en banc. And this is where Ms. Nirider wraps it up. In sum, the result reached by the district court and an appellate majority was abundantly supported by U.S. Supreme Court law while duly mindful of AEDPA's constraints. No circuit splits or questions of exceptional importance have been identified that would justify the extraordinary step of rehearing such a fact-bound case. Appealee Brendan Dassey respectfully asks this court to deny the appellate's petition for rehearing or rehearing en banc. And what she's basically saying is that to bog down all 12 judges en banc with this case, which is so fact-bound, so many interviews and things that they have to look and cross-reference and all that stuff, that it's just a huge burden on the court. So basically Ms. Nirider is just saying, you know, no matter what Schimey, Sham, and the state of Wisconsin claim, that there is no new law here. This is established U.S. Supreme Court law. Can't say it enough. The totality of circumstances with the juvenile, clearly the AEDPA standards state that with a juvenile, special care must be taken. And you saw all the examples that she cited. A lot of them were the Seventh Circuit Court itself, where that decision was made and come to by a panel of judges. Schimmel's trying to act like this is some new thing and oh my God, it's gonna tie the hands of law enforcement. No, just don't bully and stuff. Don't bully and coerce confessions out of, you know, intellectually challenged or suggestible 16-year-olds. That's it. So that's going to be about it for this video, but keep your eye out here in the next week or so, hopefully this weekend, a Brendan video that shows all of the things that happened in the interview that these judges cited in their ruling. So keep your eye out for that, and please hit subscribe.